Welcome back to The Explainer. Today, we're jumping right into a fascinating, high-stakes tug-of-war happening at the absolute peak of the legal system. When we think of the law, we usually picture something carved in stone, right? Rules that are fixed, dependable, completely predictable. But what actually happens behind the closed doors of the highest courts when those supposedly permanent rules start causing real, undeniable harm?
So let's look at this massive dilemma. How do top-tier judges balance the absolute need for legal certainty against the desperate need to fix terrible mistakes? Think about it. If a court constantly changes its mind, nobody knows what the law actually is. But on the flip side, if it never changes its mind, it risks cementing severe injustice right into the fabric of society. It's an incredibly delicate balancing act.
To understand how case law is actually a living, breathing rulebook, we're going to map out 4 specific ways the highest courts maneuver around precedent. 1. Breaking the golden rule. 2. Correcting serious judicial errors. 3. The human rights clash. And 4. The Privy Council loophole.
Okay, Section 1, Breaking the Golden Rule. Let's look at the exact moment the highest court pulled the emergency brake.
For the longest time, the absolute golden rule was that the highest court, historically the House of Lords, had to strictly follow its own previous decisions to keep everything perfectly predictable. But then came the 1966 practice statement, and honestly, it changed everything. It officially allowed the court to depart from precedent when it appeared right to do so just to avoid injustice. This wasn't just a minor tweak, it was a massive philosophical shift.
Just look at this incredibly candid confession from Lord Bridge. When correcting a highly criticized ruling that was made just 1 year prior, he bluntly stated the court was abandoning its pretension to infallibility. I mean, that is a stunning admission from the bench. Sometimes the highest judges just get it completely wrong. And when they do, a rapid demolition of that bad law is absolutely necessary.
Moving right along to Section 2, Correcting Serious Judicial Errors. Let's see how this built-in flexibility actually works when society drastically changes around the law. We can see exactly why the law has to adapt by looking at how state secrets were handled over the decades. In the 1942 Duncan case, smack in the middle of wartime, it completely made sense that a government minister's word was an absolute block on disclosing documents about submarines. But fast forward to 1968 with the Conway case, the court realized that this level of absolute state secrecy was totally unacceptable for routine, everyday matters like police reports. The new rule demanded a real balancing act between protecting the state and protecting the individual. And we see a very similar societal evolution in the realm of medical negligence. The old rule from the 1985 Sidaway case reflected a highly paternalistic standard. Basically, doctors alone got to decide what treatment risks a patient should or shouldn't know about. But by the time we hit the Montgomery case in 2015, society had fundamentally shifted. The Supreme Court established a modern patient rights approach, dictating that patients have a fundamental legal right to be warned of any material risks.
What's really fascinating here is the exact wording the Supreme Court used in their judgment. They bluntly stated that the old law under Sidaway was unsatisfactory. They were essentially admitting that everyday courts had already quietly departed from it in reality anyway. The top judges weren't just changing the law from on high, they were formally catching up to a reality that had already left the old precedent in the dust. Now, before we tackle how international courts complicate all this, let's take a quick breather for some dense legal Latin ex turpi causa non oritur actio. It's known as the illegality defense. Simply put, you cannot sue someone if your claim arises from your own illegal act. In the recent Jativia case, the Supreme Court used this exact principle to clarify that fraudulent company directors absolutely cannot use their own crimes as a shield to stop their company from suing them. It's a prime example of the court actively refining complex precedents to ensure basic common-sense justice prevails.
All right, Section 3, the human rights clash. Internal renovations of the law are one thing, but what happens when external pressures from human rights treaties force the court's hand?
Let's look at the notorious 2008 case, A v. Hoare. The House of Lords faced a truly horrific situation here. A man serving life in prison for a serious sexual assault won £7 million on the lottery. Naturally, the victim wanted to sue him, but an older, highly restrictive precedent called Stubbings v. Reb said she was legally out of time. To avoid a massive injustice, the House of Lords completely reversed course, overruled Stubbings, and let her sue. The attacker, incredibly enough, cried foul. He appealed to the European Court of Human Rights, claiming the British judges had unfairly changed the rules retrospectively.
While the European Court shot his appeal down immediately, they affirmed that adapting to changing circumstances is just an inevitable, built-in feature of any legal system.
They essentially told him, look, that's just how the common law works. Judges interpret and adapt.
But, this dynamic between domestic and international courts isn't always quite so harmonious. Which brings us to a rather dramatic concession by Lord Hoffmann in a totally different case. He declared, "Strasbourg has spoken, the case is closed." And he said this with considerable regret, noting that even if the domestic judges thought the European Court was flat out wrong, they had no choice but to submit because of international treaty obligations. It perfectly captures the intense tension at the very top of the legal hierarchy.
However, the newly formed Supreme Court soon adopted a much more confident stance. Lord Phillips suggested that, while the domestic court absolutely must take decisions from Strasbourg into account, there is room to push back. If the domestic judges feel the international court has completely misunderstood their processes, they can politely decline to follow the decision to spark a constructive dialogue. It's a brilliant legal check and balance that prevents blind obedience.
Finally, Section 4, the Privy Council loophole. Let's untangle a bizarre constitutional anomaly, where a lower court effectively staged a brilliant, entirely legal coup against the House of Lords.
So, imagine this dilemma. The House of Lords makes a deeply criticized ruling on the law of provocation in murder cases. The entire legal world knows it's a flawed decision. The highest judges themselves know they need to fix it, but because of the strict rules of precedent, they can't just issue a memo saying, "Oops, we messed up." They literally have to wait for a matching case to be appealed all the way up to them. What on earth do they do when their hands are tied by their own rules?
Well, here is how they engineered a completely bizarre, genius solution. In 2001, the House of Lords made that controversial Morgan Smith ruling. A few years later, a very similar case called Hawley came up, but this one was from Jersey. Now, Jersey cases go to the Privy Council, not the House of Lords. And technically, the Privy Council doesn't bind English courts. But in a massive stroke of strategic genius, 9 law lords sat on that Privy Council board, essentially wearing a different judicial hat for the day, and boldly declared their own previous English ruling was wrong. Then, when an actual English case finally hit the Court of Appeal, that lower court had to decide, do we follow the official House of Lords precedent, or do we follow this new, technically non-binding Privy Council decision?
The Court of Appeal practically shrugged its shoulders and chose the Privy Council. They realized the old hierarchical rules had been totally shattered. Because the law lords themselves deliberately used the Privy Council as a backdoor device to subvert their own bad precedent, the Court of Appeal just played along in the pursuit of correcting a fundamentally flawed law. It was a truly remarkable moment of judicial realism winning out over strict procedural tradition.
And that brilliantly illustrates the core tension we've been tracking today. As we wrap up this explainer, I want you to consider this final question. Where should the line ultimately be drawn? I mean, we need the law to be predictable so society can actually function, but we desperately need it to be flexible enough to prevent tragic injustices. So, should unelected judges have the power to rewrite the rules when they see a mistake, or is the strict certainty of a flawed law sometimes just the price we have to pay for a stable society? It's a massive debate that continues to shape every major case reaching the highest courts. Thanks for joining me on this deep dive, and as always, keep questioning the rules.